Fourth cause of action, First Amendment violation. 184, Disney realleges and incorporates by reference all preceding paragraphs. 185, Disney's public statements on House Bill 1557 are fully protected by the First Amendment, which applies with particular force to political speech. Speech such as Disney's on public issues and petitions to the government occupy the core of the protection afforded by the First Amendment. And there are several references there you can look at. First Amendment protects speech intended to influence public opinion and, in turn, any proposed legislation. 186, CFTOD's retaliatory interference with the contracts via the legislative declaration and its predicates has chilled and continues to chill Disney's protected speech. Bennett versus Hendricks is referenced, discussing action that would likely deter a person of ordinary firmness from the exercise of First Amendment rights. This unconstitutional chilling effect is particularly offensive here due to the clear retaliatory and punitive intent that has motivated CFTOD's actions at the governor's directive. See Bailey versus Wheeler. Our First Amendment demands that a law enforcement officer may not use his powerful post to chill or punish speech he does not like. 187. Disney has a significant interest in its own contracts, which have been directly targeted by the legislative declaration. Disney faces concrete, imminent, and ongoing injury as a result of the contractual impairment. 188. CFTOD's actions were motivated by retaliatory intent. On April 17th, Governor DeSantis warned that the CFTOD board would be meeting a few days later to, quote, make sure Disney is held accountable, end quote. Later that day, Governor DeSantis announced, quote, I look forward to the additional actions that the State Control Board will implement in the upcoming days, end quote. Governor DeSantis has let no doubt be harbored as to the impetus for his punishment. He wrote in an article to promote his book, when corporations try to use their economic power to advance a woke agenda, they become political and not merely economic actors. Leaders must stand up and fight back when big corporations make the mistake, as Disney did, of using their economic might to advance a political agenda. 189. There's no rational basis to invalidate the contracts, and the purported justifications for doing so are pretextual. 190. Because the legislative declaration retaliates against Disney for its protected speech, Disney is entitled to a declaratory judgment that the legislative declaration is unconstitutional and an order enjoining defendants from enforcing it. Fifth cause of action, First Amendment violation. 191, Disney realleges and incorporates by reference all preceding paragraphs. 192, as discussed, Disney's public statements on House Bill 1557 are fully protected by the First Amendment, which applies with particular force to political speech. 193, the retaliatory reconstitution of Disney's governing body's structure through the enactments of Senate Bill 4C and House Bill 9B have chilled and continue to chill Disney's protected speech. This unconstitutional chilling effect is particularly offensive due to the clear retaliatory and punitive intent that motivated the governor's and the legislature's actions. 194. Disney has significant interest in its governing body's composition structure, which has been directly targeted by the enactment of legislation providing for its complete revision. Disney faces concrete, imminent, and ongoing injury as a result of CFTOD's new powers and composition. 195. Senate Bill 4C and House Bill 9B were motivated by retaliatory intent. Governor DeSantis would not have promoted or signed, and the legislature would not have enacted either bill, but for their desire to punish Disney for its speech on an important public issue. See Warren, 2022, it's a reference, crediting sources of information about the governor's motivation for suspending a prosecutor, including a tweet from the governor's press secretary and comments during the governor's announcement of the suspension. 196. Governor DeSantis called on the legislature to extend its special session for the express purpose of enacting Senate Bill 4C the very next day after Disney made a statement about House Bill 1557. He repeatedly and publicly stated that he was fighting back for Disney's criticism of House Bill 1557, including at the bill signing ceremony. Key legislators publicly acknowledged that Senate Bill 4C targeted Disney. 197. The law's passage was highly irregular. The bill was added to a special session convened for other purposes, even though there was no emergency that would justify such rushed treatment. RCID had existed for decades, and Senate Bill 4C did not propose dissolution until June 2023. The bill passed only 3 days after identical bills were simultaneously introduced in the House and Senate. There was no debate in the House. Stakeholders did not have time to conduct their own analysis. And no concrete plan to effectuate the dissolution of RCID or address the ramifications of doing so was proposed in the months following the legislation's hasty enactment. Departures from the normal procedural sequence might also afford evidence that the improper purposes are playing a role. Substantive departures, too, may be relevant, particularly if the factors usually considered important by the decision maker strongly favor decision contrary to the one reached. And that is a quote from something Arlington Heights versus Metro House. So that was also a reference you can look up. 198. The circumstances surrounding the passage of House Bill 9B reveal the same retaliatory targeting. Again, a special session was convened and the legislature passed the bill within days of its introduction. During the Senate's floor session, Senator Doug Broxson confirmed that the bill was punishment for Disney failing to be apolitical. Senator Broxson said, "We joined with the governor in saying it was Disney's decision to go from an apolitical save 25,000 acres and try to be involved in public policy. We're saying you have changed the terms of our agreement, therefore we will put some authority around what you do." Governor DeSantis in a recent article gave the following context for House Bill 9B. When corporations try to use their economic power to advance a woke agenda, they become political and not merely economic actors. Leaders must stand up and fight back when big corporations make the mistake, as Disney did, of using their economic might to advance a political agenda. 199. There are no rational basis for either Senate Bill 4C or House Bill 9B, and the purported justifications for both are pretextual. 200. Because both pieces of legislation retaliate against Disney for its protected speech, Disney is entitled to a declaratory judgment that the laws are unconstitutional and an order enjoining defendants from enforcing them. Prayer for relief. Plaintiff respectfully requests that this court grant the following relief. A. Declare that the legislative declaration is unlawful and unenforceable because it abrogates Disney's rights in violation of the Contracts Clause. B. Declare the legislative declaration is an unlawful taking of Disney's property rights without payment of just compensation in violation of the Takings Clause. C. Declare the legislative declaration is unlawful and unenforceable because it was an arbitrary and irrational voiding of the development agreement and restrictive covenants in violation of the Due Process Clause. D. Declare that the legislative declaration is unlawful and unenforceable because it was enacted in retaliation for Disney's speech in violation of the First Amendment. E. Declare that the contracts remain in effect and enforceable. F. Declare that the Senate Bill 4C and House Bill 9B are unlawful and unenforceable because they enacted a retaliation for Disney's political speech in violation of the First Amendment. G. Issue an order enjoining defendants from enforcing the legislative declaration. H. Issue an order enforcing defendants from enforcing Senate Bill 4C and House Bill 9B. I. Award plaintiff its attorney's fees and costs. J. Grant such other relief as this court may deem just and proper. And that is the end. And you can look at the signatures of the attorneys.